And I'm sure this interaction would yield positive results in the realm of company law and corporate governance. I believe wherever we have corporate governance and laws, there are issues which crop up and which require further amendments in law and positive action from the SCCP. I have a question which I often think and I wanted to share with you at the beginning of this session, and that is, I've seen in last couple of years, whenever there is a allegation of corporate offense, NAB becomes more proactive than SCCP. Why is that? No, but is it not a reflection of, I'm sorry to use this word, laid-back approach of the SCCP?
In three of the reported judgments, I carved out Section 41B of the SCCP Act by declaring SCCP as a regulator, and under the 97 Act of SCCP Act. And when the case of PGM Consortium and the Al Arabia Sugar Mill and Ramzan Sugar Mill, they tried to intervene into the Companies Ordinance Act also to take action against the persons under that law. But then one of the judgments which has successfully handled and NAB withdrew their notices and actions, because that's the 2020 CLD 518 PGM Consortium, that under Section 41B of the SCCP Act, which is a regulator, as declared by one of my judgments, 2021 CLD 931, which says that SEC being a regulator, how it regulates the affairs. Under 41B is notwithstanding anything contained in any law, SECB has an overriding effect of that law. So that regulator is protected by its own section. And then Section 4 of the Companies Act 2017, Section 4B also states that because preamble, if read, preamble says this law to reform the company law. And preamble read with Section 4, which says, notwithstanding anything contained in any law, no matters can be taken except under the Companies Act. So two provisions were successfully done. NAB proceedings of PGM Consortium, Al Arabia Sugar Mill, Ramzan Sugar Mill, and Asgard 9 were taken back. And then I don't think so they have intervened after that.
I think we are more concerned about the performance of SECP rather than invasion of the NAB. So we are here to discuss the capacity of SECP, whether they could deliver in view of the situation that is just highlighted by my lord. Do they have enough competence and capacity not to be invaded by NAB or any other investigating agency? That is the question.
Perhaps, Mr. Mirza, we are out of the agenda. If we confine ourselves to the topic first, and then we take question and answers, that would be much appropriate, because it will never end, and it will go on and on.
I'll just quickly answer. Yes, my lord, we are very equipped. We have one of the, even the NAB and any other agency that investigates any of the offence which relates to company, they request our officers to be deputed. So in fact, none of the agencies has the requisite qualification except the SCCP, because this is our daily business. That's what we do. Sir, thank you very much. You very quietly, rightly pointed out.
Would you permit me to say something
please,
on the topic first?
Sir, please.
So, initially, I think the topic which was provided to me, at least, was about panel discussion on insolvency and liquidation,
Yes.
bottlenecks, solutions, and legislative reforms. And then it was changed to application of Company Code Rules 1997. Perhaps I don't know why it has been done, because these rules are now just a stopgap arrangement, and we are like using these rules just because we don't have other rules. So coming to the bottlenecks and solutions, and whatever I am expressing is, with my experience as a company judge for around 2 years in the Sindh High Court. Presently, I am not the company judge. We have in Sindh High Court a system not of nominating a specific person, but the senior most judge sitting on the original side is the company judge on the roster. In liquidation matters, what I have seen is that SECP by itself as a regulator is not aware about the company's details and their assets and their financial data as well as the assets they have, the company has, and it seems that the entire responsibility is shifted to the official liquidator to hunt for the assets. So my suggestion and experience shows that you must have the complete real-time assets and details of the companies. You should have linkage with the departments where the assets are recorded and sold and siphoned off. So you should have this on real-time basis. You have the system of filing returns 90 days period or 6 months or yearly. That is not going to help because if a person is intentionally siphoning off the assets before the company goes into liquidation, so the assets would be gone when it is finally it has come to winding up. You must have details of the directors, their associated companies and their other particulars, because I had a case wherein there was a company under liquidation, a winding up order had already been passed. SECP was the petitioner. SECP had also filed a complaint, criminal complaint. That gentleman was attending the complaint but was never coming up to the court. For 3-4 years he didn't turn up to file any statements, anything to the court. So as a last resort I blocked his CNIC, and the next day he was before the court begging to get the CNIC deblocked, and he was willing to provide all the details. So these details should always be with SECP, and then the court and the official liquidator can look into it. Then in liquidation proceedings, you have your lawyers coming up to the court, but post winding up order, it's more of like facts to be determined and the help needed by the liquidator. So you must have some liaison person with the court to coordinate with the official liquidator as well as the company registrar and the other officers of the court, because the exercise is going on between the official liquidator and the court and carries on, and SECP is sitting without any help. So and secondly, in addition to lawyers, you are having experts on all fields. So you must also have your officers coming to the court regularly in issues which are not germane to the field of law and require assistance on their expertise. As to section 5 and 6, we have heard yesterday a lot of things. So the legislative reforms and your law that requires that there should be a company judge in the High Court, perhaps that would be a very difficult proposition to continue. I don't think any Chief Justice can spare his one judge for the company bench exclusively. So especially in our High Court, the jurisdiction, the High Court judge also exercises the original civil jurisdiction, and the company judge has to look after urgent matters, commercial matters, and a lot of other things. So I don't think he will be in a position to perform all these duties timely. So I would suggest is that you look into the Indian Companies Act and try to go through sections 408 and 410 of the 2013 Act of India. They have way back in 2002, even in the earlier law, they have constituted company law tribunals. And there are two tribunals. One is the first forum, which is the company law tribunal under section 408, and the composition they have made is like of experts. The president of the tribunal is a person who is qualified to be a judge, and then there are judicial and technical members who have experience, just like chartered accountants and cost accountants, and company secretaries can be appointed as technical members, whereas judicial members can be appointed amongst from the lawyers and the district judges. Then they have the appellate tribunal, which is to be chaired by a judge who has been the judge of the Supreme Court only, or a Chief Justice of a High Court. So it's a very high level forum, and it has taken care of all the company matters, and the burden from the courts has been reduced, and the performance of the tribunal, as I have gone through, is very good, and they are like deciding matters in the timely provisions. Then this appellate tribunal also have judicial members who can be who can be a judge of the High Court or has remained a judicial member of the earlier tribunal for 5 years. And technical members, they have a requirement of 25 years experience in management, industrial finance, and cost accountants. Then coming to the other difficulty which we face is appointment of official liquidators. I'm not sure about the other high courts, but in Sindh High Court we have one official assignee who is already appointed under the Karachi Division Insolvency Act of 1906, and we take assistance from him as our official liquidator because you are still not able to issue a panel of liquidators. In one case I had given certain directions and there was some list provided by SECP, but I don't think that you have notified such panel. So you need to immediately comply with section 315 and form a panel of liquidators amongst from the chartered accountants, advocates. You should also look for company secretaries. Those who have performed their jobs as company secretaries could also be a very good help to your panel. Then you can also engage firms having all these compositions of accountants and advocates. As to our court dependency, like our official liquidator is, official assignee is the official liquidator in 70 cases. The law provides that no person can be an official liquidator for more than 3 companies. So we have 70 cases with him after winding up, and the earliest of the case is of 1968. And the reason being is that no information is available with the court to pass a final dissolution order. So either there could be a provision that by the lapse of time and dissolution order has to be passed, the creditors go home and the case is closed. But this is not provided in law, so we are keeping on like hunting for things, and files are piling up. Then you also need to look into the liquidators remuneration. If you want a company to be wound up in a certain period of time, in 6 months time or maybe 1 year time, so the official liquidator would always be performing well when he is paid good, because you appoint liquidators amongst the lawyers, and lawyers are the biggest money makers perhaps. So no offense to my learned advocates sitting here. Then there was some suggestion by one of your presentations that you intend to amend the law to transfer certain things from the courts to SECP. I think you don't need to amend the law. The law is already there. Go through section 280 to 282. All such powers are conferred with SECP, but by virtue of section 285 subsection 8, you have made some unwarranted legislation by transferring this jurisdiction to the courts. You just need to omit section subsection 8 of section 285, and you will have the powers of reduction of share capital, the compromises, the amalgamations, and all such ministerial work. Because what I have seen is that they come up to the court, and there is a lot of compliance required in that, publication, meetings and all, and then we pass an order. The issues should come to the court only when there is some objection, there is an objector. Then you come to the court for a decision. But where there is no objection, like reduction of share capital, and cases are coming up and we are deciding, and I don't think there is any adjudication into it. So take back these powers to you, please. We don't want them. Then there is one more thing which has been noticed while dealing with winding ups, that the concept of holding companies and the associated companies and the subsidiary companies, these provisions are being extensively misused by persons who intentionally defraud people, and the creditors are running the associated companies and the subsidiary companies are making money, and the company under liquidation is going down and nothing is coming out. So you need to look into this aspect and to ensure that the money of the principal company, especially the public companies, is not siphoned off in a manner that the associated companies become richer and the original company goes in liquidation. And lastly, like for SECP, I think they believe that if a winding up order is passed, they have done their job in assistance. but it is the other way around. I think your work starts once the liquidation order is passed. Once the winding up order is passed, then your work starts to get that company fully liquidated and dissolved under the rules. And lastly, there's one suggestion, like I've seen winding up petitions coming up from creditor banks now. There are 2-3 banks in Karachi which have come in liquidation, and at least to my extent, I did not issue notices even, because what was done is like they lent money against hypothecated stocks which were siphoned off, and instead of going for a recovery suit, they took this chance to come up in liquidation. And recently the Honourable Supreme Court in one of the cases, in Bank of Punjab cases, has said that no liquidation is, at least to a very large extent, would be possible by a creditor bank. So you need to cut off this and reduce the work on the court, because the banks are coming up for liquidation as the creditors. So these are my suggestions, and questions, if any, would be welcome.
My lord, they're music to our ears. I think there's nothing I can say.